And just like that, I am hooked back in. Hello, my fam. It is Perez, the queen of all media, the original influencer, journalist, podcaster, and your number one source for everything It Ends With Us saga. This saga is better than any soap opera because it's real and there are more twists and turns. This latest development has just caused me to go, what? ¿Qué? Just a few days ago, I told you all that Team Baldoni Wayfarer filed a motion to serve a subpoena on young Lily Bloom. They had been trying to serve her, so they went to the court to file this request for alternative service. We have seen the docket Duchess use this play many times, and her lapdog, Judge Lyman, granting those requests repeatedly. So it seemed sensible to me that the Baldoni Wayfarer parties would do the same, especially because, according to them, the Nepo baby, that's right, Isabela Ferrer, is the granddaughter of the late Rosemary Clooney, and George Clooney is her second cousin? I messed that up. Isabela Ferrer. I'm probably going to mess that up again. You guys, here and now, I am confirming her name is Isabela Ferrer. But if I say Isabel, just go with it, okay? They claim that she was evading being subpoenaed, even though they had been in communications with her lawyer, who then ghosted them. Well, like Jesus, young Lily Bloom's lawyer is back from the dead and just filed an explosive game changer with Judge Lyman. Let's get into it. And yes, some of you might remember that Isabela Ferrer was on Justin Baldoni's side until Blake Papini sunk her claws into her. Back in July of 2023, a year before this drama became public, Isabela Ferrer texted Justin Baldoni thanking him for such a wonderful experience on the set of It Ends With Us. Isabel filmed for just 4 days and did not act opposite of the authorship thief. But then, as many of you know, promo for the movie began. And unfortunately for him, the lively liar alienated Baldoni from the rest of the cast. The grifting girlie did the promo with Isabela Ferrer and the rest of the actors, and without the director, or initial director, before he was replaced. And then in the fall of last year, in October to be exact, well after the film's August release and promotion was over, Isabela Ferrer and Butthole Lively were spotted out to dinner together in New York City. In July of 2023, she texted Baldoni, "I have to say thank you so much for an incredible experience on my first film. I still can't shake the feeling of it all because it truly was life-changing for me. You are such a wonderful, smart, and sincere director, and you created such a comfortable, safe space for me to feel like I could fully step into this role. I couldn't have asked for a more welcoming environment. It will stay with me for the rest of my life." Well, things sure have changed. Isabela's lawyer, who could accept service on her behalf, just filed a motion telling Judge Lyman, Slimy Lyman, not to grant the Baldoni Wayfarer's request for alternative service. Huh? Why? Young Lily Bloom's lawyer tells the court, quote, "The instant motion for leave to serve third-party Isabela Ferrer by alternative service motion is yet another attempt by Justin Baldoni and his affiliated entities, collectively Baldoni, to harass non-party Isabela Ferrer and draw her deeper into litigation and disputes she has done her best to avoid. This is Miss Ferrer's first filing in this court, but she was pulled into the discovery fray in February 2025 when Blake Lively delivered a subpoena to her. Lively subpoena to delve into allegations about Miss Ferrer that Baldoni included in his original complaint. In response, Miss Ferrer tendered a demand for indemnity to It Ends With Us Movie LLC, as mandated in her day weekly player contract for theatrical motion pictures acting agreement, which, by the way, the Baldoni Wayfarer parties agreed to. They agreed to that. I looked at all of the exhibits, the evidence, the receipts that Isabella's lawyer submitted, and Team Baldoni Wayfarer said, okay, we'll do that. From that point forward, her lawyer tells Lyman, quote, Baldoni has tried to manipulate, threaten, control, and otherwise act inappropriately towards Miss Ferrer. You know what I find very telling about this? The decision to call Baldoni and the Wayfarer parties Baldoni instead of the Wayfarer defendants or the Baldoni defendants or anything else but Baldoni. Saying Baldoni when they're talking about more than just Justin was a calculated move here. Her lawyer says, in fact, Baldoni's legal team has gone as far as citing a phony case which Miss Ferrer's counsel discovered as an AI hallucination to support a frivolous legal position. They don't mention what that is. Usually a good lawyer, not me, because I'm not a lawyer and I've filed some hallucinations, would add a footnote letting the judge know what they're talking about. Isabella's lawyer did not do that. But it does not stop there. The letter continues. But it did not stop there. See what I did there? The filing of the instant motion is yet another attempt to manipulate the press. Pause. Are we sure Ryan Reynolds did not write this? Or ethically challenged Ezra? It's got their fingerprints all over it, I think, in my opinion. The filing of the instant motion is yet another attempt to manipulate the press to create havoc on a young, up-and-coming, and talented actress, and to violate this court's policies on the publishing of non-party personally identifying information. Pause. This is absolutely Ezra in action, I believe, my opinion, allegedly. And why I believe that is because there's a lot of misrepresentation happening here. Now, you know I'm team the truth. And when the Baldoni Wayfarer parties listed Isabela Ferrer's 2 known home addresses, what did I do? I called them out on that publicly. I said they could have filed that redacted version for the public docket and the unredacted version under seal for the court. And the Baldoni Wayfarer parties did not. However, when they did that, even though I disagreed with that decision and I called them out for it publicly, they did not violate the court's policies on the publishing of non-party personally identifying information. Don't get it twisted. You don't need to lie or misrepresent the truth. Be honest. Lawyers. Her lawyer continues. As set forth herein, there is no need for the court to grant the press-garnering motion, but instead sanction Baldoni for engaging in such obvious sharp practice. Huh? Sanction? Or how's about you just accept the subpoena, like you accepted the one from Blondie? No. Her lawyer says the primary reason to deny the motion is that it fails to meet the applicable legal standard for the relief Baldoni seeks. Baldoni prematurely brought the motion without conducting the diligence necessary to support a motion for leave to serve a discovery subpoena on Miss Ferrer by means other than personal service. The motion discloses no efforts made by Baldoni to determine Miss Ferrer's actual residential or business address, nor does it offer a scintilla, that's a good word, of evidence to demonstrate that Miss Ferrer has in any way attempted to avoid personal service of Baldoni's July 3rd, 2025 document subpoena, the Baldoni subpoena. Bruh, why are you wasting the court's time and don't just accept the subpoena? Her lawyer says, to the contrary. By responding to the lively subpoena, Miss Ferrer has already proven that when faced with a valid subpoena in this matter, she will comply with her obligations. There is no proper foundation to support the motion, and Baldoni's true motivations will be revealed herein. Unfortunately, the motion is just the latest in a broader pattern of conduct by Baldoni to bully Miss Ferrer. That's a big accusation. Earlier, Baldoni tried to leverage compliance with contractual indemnity obligations owed to Miss Ferrer in an effort to take control of Miss Ferrer's response to the lively subpoena. Baldoni then tried to leverage compliance with those same indemnity obligations as a quid pro quo for Miss Ferrer to instruct her attorney to accept service of the Baldoni subpoena on her behalf. Stated another way, thank you, Baldoni refused to honor contractual obligations unless Miss Ferrer agreed to certain demands. Miss Ferrer rightfully refused to tie her indemnity rights to any other issue in Baldoni's dispute with Lively. While Miss Ferrer will faithfully comply with her legal obligations under any subpoena, summons, or court order, she will obviously not be intimidated or extorted by any party to otherwise participate in the proceedings. It seems like a misrepresentation again. I don't know. Finally, though the motion does not directly raise the substance of the Baldoni subpoena, the court should consider it when determining whether to give Baldoni special treatment for the manner in which it is served. Oh boy, no, baby, no, baby, no. Snively would not be giving Baldoni special treatment. The judge would be giving him equal treatment because he's agreed to do this for La Bruja many times. Young Lily Bloom's lawyer, though, says, even the most cursory review of the Baldoni subpoena demonstrates its harassing nature. For example, it demands the production of all documents produced in connection with any subpoena in the action. How the hell is that harassing? The attorney says, There is no rational reason to demand that Miss Ferrer, who is not a party to this action, reproduce materials that have already been produced by her or others in the litigation. All right, that makes sense, ... but not really. It would make sense in a normal situation. However, Team Ridicula has accused the Baldoni Wayfarer parties of submitting incomplete evidence. They don't trust him and the other defendants. And if I have to read between the lines, it seems to me that the Baldoni Wayfarer parties might think that Isabela Ferrer has come under the influence of Pinocchio and might also not have been fully forthcoming, did not produce everything that was requested. This is nasty. This is a nasty, 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 nasty ongoing litigation. So, young Lily's lawyer says, for all these reasons, which are discussed at length below, Miss Ferrer respectfully asks the court to deny the motion in its entirety and impose appropriate sanctions against Baldoni. Dun, dun, dun. Listen, I do feel bad for this girl, especially because, as this says, although her role in the film was important, she only spent 4 days on set and was paid a small sum for her work. She has little to do with the operative facts and events of this case, but that has not stopped her from being pulled into the dispute by Baldoni in a number of different ways. But yeah, according to you yourselves, La Lively pulled young Lily into this first. Keep it real and equal, okay? And remember those text messages that I read to you earlier? They bring that up. Isabella's lawyer says, the 179-page complaint Baldoni filed against Lively makes 4 direct references to Miss Ferrer and includes screenshots of a few text messages Miss Ferrer sent. Not surprisingly, some of the text messages Miss Ferrer sent Baldoni were very positive and included the types of comments one would expect from a young actress to make to the director and producer of her first feature film. Baldoni used these texts to craft the narrative that after Miss Ferrer spent substantial time with Lively during film promotions, Miss Ferrer felt compelled to shun Baldoni in repudiation of her warm words. Yeah, it sure does seem like that. And you're only making it seem more so now. However, her lawyer says, Baldoni's complaint made no other allegations that directly reference Miss Ferrer. Baldoni's lawyer-crafted narrative is far from reality or the true facts, but nonetheless, it created a situation where even those minimal allegations were enough to drag Miss Ferrer into this litigation. Stated more bluntly, Baldoni Ryan Reynolds. You scab. Scabbing some more. Stated more bluntly, Baldoni appropriated Miss Ferrer's narrative without her permission, simply to create a self-serving image for the public and the press. Ironically, the allegations against Baldoni are those that mimic a harasser, and his recent actions surely support that view. Wow. I mean, I definitely think the Baldoni Wayfarer parties could have handled this better. Look at me, Team Truth again. According to this filing to the court, Isabella's lawyer says, "It ends with us, LLC, conditionally agreed to indemnify Ms. Ferrer as required by the acting agreement. The condition, however, was a serious one. The February 28th letter demanded that Ms. Ferrer confirm that she will surrender control of her response to Wayfarer." I don't think that was necessary. Drama. The filing says, meaning the Baldoni team sought to respond for Ms. Ferrer however they wanted, not actually allowing Ms. Ferrer to provide the documents that reveal the true facts. Wow, this is explosive. This is explosive. The true facts, how this is all worded. This is a big hit, I think. This is real bad for the Baldoni Wayfarer parties. It's bad, period. And pre all of this, Justin Baldoni would have said so too. Her lawyer continues, "Ms. Ferrer was not willing to turn over control of her response to the lively subpoena to Baldoni or anyone else for that matter, which led to a protracted dispute over It Ends With Us LLC's indemnity obligations. Aspects of that dispute help explain Ms. Ferrer's frustration with her dealings with Baldoni and his counsel, with him directly, as well as the distrust those dealings have fostered." Drama. They say It Ends With Us LLC fought over its claimed right to control Ms. Ferrer's response to the lively subpoena, or at a minimum, unilaterally select her counsel. Jeez Louise. They also claim that Baldoni tried to pressure her by making Isabella incur legal costs. Her lawyer tells the judge, "It Ends With Us Movies LLC's conduct in negotiating the terms of the indemnity greatly delayed the process and any related indemnification to Ms. Ferrer in a transparent attempt to put financial pressure on Ms. Ferrer as her legal costs mounted." Those delays continued even after the parties entered into a written contract in late May 2025, which defined a process that would allow a neutral retired judge to review Ms. Ferrer's attorney invoices to determine whether the services and fees billed are subject to indemnification under the acting agreement. Y'all, oh my God. I keep going back to what I told you all a couple of days ago. If Baldoni and his producing partner had agreed to release that cockerific statement that the second wife of Ryan Reynolds wanted him to put out, so much drama and turmoil and millions, and in the case of this girl, tens of thousands would have been saved. And just the energy and just, oh God, craziness. This is all so crazy. They tell the judge, in fact, it was during the time period when Ms. Ferrer was pushing to engage the agreed upon neutral judge that Baldoni reached out to Ms. Ferrer's attorney about accepting service of the Baldoni subpoena. Although the motion discusses the initial part of that outreach, it omits the salient facts that followed in violation of the well-settled obligation of candor to a tribunal. They claim Baldoni made accepting service of the Baldoni subpoena a quid pro quo to move forward with the process for handling contractual indemnification obligations owed to Miss Ferrer. Meaning, they were dragging their feet, agreeing to pay this girl all of the legal fees that she was incurring in relation to now the 2 subpoenas. Additionally, they are salty because they claim Baldoni's motion for alternative service led to negative publicity for Miss Ferrer. That is true. They then go and argue all of the relevant case law and why the judge should side with Team Young Lily Bloom. Oh, good news. We find out now that neither of the 2 addresses that were listed on the public court docket are where Isabela Ferrer live. Good to know. But they also argue that the Baldoni Wayfarer parties did not do their due diligence in trying to find her home address or business address. Maybe because they didn't feel like they needed to. They were talking to her lawyer. And her lawyer is doubling down, saying the purpose of that, the motion for alternative service, and the underlying subpoena is to harass Miss Ferrer as part of a broader, coordinated campaign against her. Oh my God, I'm getting PTSD from the language. This has Lively Reynolds all over it. But they do make some good points. And so far they have made some good points. It says here, a subpoena that requires a non-party to produce documents produced in connection with any subpoena in the action is not aimed at uncovering new evidence or information. Those documents are, by their very nature, materials the parties have readily available to them in the litigation. But remember what I said about the distrust? Instead, the motion and the Baldoni subpoena are transparent efforts to exert pressure on Miss Ferrer, both in this litigation and in connection, oh my God, in connection with other pending disputes? Does that mean there might be another lawsuit that is filed? I can't handle that. I can't handle that. No, please, no. Isabella's lawyer says, rushing to file the motion before conducting the necessary diligence to support a proper request for service by alternative means allowed Baldoni to publicly disseminate addresses that could have been Miss Ferrer's home. True. This sort of conduct from Baldoni, and Lively too, is not new, and Baldoni has been improperly attempting to exert control over Miss Ferrer ever since Miss Ferrer received the Lively subpoena. They then remind the court Baldoni used the motion to publicly disseminate personally identifying information of non-parties, which Lively has done way more. They argue Baldoni previously tried to leverage indemnity obligations owed to Miss Ferrer to control of Miss Ferrer's response to other discovery directed to her in this litigation. And because of that, they say, allowing Baldoni to use lesser alternative means to serve Miss Ferrer with the Baldoni subpoena effectively punishes Miss Ferrer for refusing to bend to Baldoni's intimidation and may only serve to encourage more inappropriate behavior. Ouch. They argue that Baldoni's subpoena largely covers material that Lively's subpoena covered, highlighting the harassing nature of Baldoni's discovery conduct. There's a whole sanction about how Baldoni's conduct warrants sanctions pursuant to Rule 45, Subdivision D. I should probably file a letter to the court about this. Rule 45 provides the court with the authority to protect non-parties from misuse of the subpoena process. More specifically, Rule 45D1 allows the court to monetarily sanction a party responsible for issuing and serving a subpoena where the party fails to take reasonable steps to avoid imposing undue burden or expense on a person subject to the subpoena. Good to know. The measure of sanctions prescribed by Rule 45D includes the attorney's fees and expenses incurred in challenging the sanctionable conduct. That's probably a lot by now. Expensive lawyers for months. Ay, ay, ay. Should the court conclude that an award of fees and costs is appropriate, Ms. Ferrer respectfully requests that the court set a briefing schedule for the calculation of that award. Conclusion. Baldoni has not met the threshold for seeking to serve Ms. Ferrer by means other than personal service because Baldoni cannot show the requisite diligence to support such a request. Rather, Baldoni filed the motion for improper purposes with the aim of harassing Ms. Ferrer. Ms. Ferrer respectfully asks the court to deny Baldoni's motion and take appropriate action to protect the non-party PII that Baldoni so recklessly disclosed publicly through his filing. Ms. Ferrer also asks the court to consider appropriate sanctions against Baldoni for his bad faith tactics. Respectfully submitted. Ay, ay, ay. And this is why I'm so good, y'all. This is why I'm so good. I've said it time and time again. It would not surprise me if both sides eventually agree to a settlement. And maybe even soonish. The longer this drags on, the worse it is, I think, for both sides. This filing, not a good look for Justin and crew. However, I'm really curious to see their response. We should hear both sides. Wild. What do you think of this all? Let's discuss everything in the comments section. Ay, ay, ay.